Right, well, good afternoon, everybody. My name's Kate O'Regan. I'm the director of the Bonavero Institute of Human Rights at the University of Oxford, and welcome to this week's edition of the Bonavero discussion group. We're particularly delighted to be welcoming two experts in the field of citizenship and statelessness today. The first is Amal de Chickera, who's the co-director and co-founder of the Institute on Statelessness and Inclusion. One of the very few, perhaps the only, human rights organization working on issues related to nationality and statelessness. Amal has been an activist in the field for well over 10 years. He also teaches at Middlesex University and does a whole range of work in this field. So we're really delighted to have you here, Amal. And then Amal's presentation will be responded to by Christopher Bertram, who's Emeritus Professor of Social and Political Philosophy at the University of Bristol, and the author most recently of Do States Have the Right to Exclude Immigrants? His work has covered philosophy, social theory, and is particularly interested in this field as well. So I'm sure we're going to get a very interesting perspective from him. As you know, what will happen is that you will have an opportunity to put questions to our two speakers. You'll see that the Q&A button, if you've been away for the last year, is at the bottom right hand of your Zoom screen. And Gayatri and I will moderate the questions, so please feel free to put questions there, and we will aim to finish just before 2 o'clock. So over to you, Amal.
Thank you so much, Kate, and for the kind invitation to speak at this discussion group. I first met Kate when I was working at an organization called the Equal Rights Trust, and Kate was one of the trustees. And it's so nice to be able to reconnect with you all these years later and be in a position to share this space with you. So I'm very grateful for the opportunity. Okay, so let me start. I'm going to be talking about the implicit international law prohibition of citizenship stripping as a national security measure. Now, what can the Merchant of Venice teach us about contemporary international law standards related to the deprivation of nationality? Perhaps not very much, in which case I apologize for collectively wasting our time today. But over the past few years, as I've been working on the issue of citizenship stripping, I've been really thinking hard about how to best articulate what I have learned and understood the international law position to be. That it's not a blanket prohibition, but a set of standards, both weighted and strong, which collectively make it virtually impossible to engage in citizenship deprivation if acting in good faith and complying with international law. Thinking about this dilemma of how to articulate this, it struck me very annoyingly about half an hour after a similar event to this last year, that there was a very strong analogy to be made with the concept of the pound of flesh in Shakespeare's Merchant of Venice. And so I revisited the text of the play and looked at it more closely, and was struck that there were a number of analogies, actually, not just one, and a number of comparisons to be drawn, particularly from the famous courtroom scene of the play. So in this talk, what I would do is I would pick out 4 of these analogies and comparisons. And through looking at them, I will attempt to further explore the legal and other factors at play when states make it their business to engage in the practice of citizenship deprivation. But first, let me very quickly refresh any memories that need refreshing in terms of the play, and in particular, the courtroom scene. So as the story goes, Antonio, a wealthy merchant, borrows money from Shylock, who's a moneylender, and he does so in order to help out his friend Bassanio. There is now no love lost between Shylock and Antonio, and so Shylock stipulates quite a strange and deadly bond: a pound of Antonio's flesh should he fail to repay the loan. As fate and plot development would have it, Antonio is unable to pay the loan, and Shylock demands his penalty. In the courtroom scene which follows, in a very highly dramatized setup, Portia, to whom Bassanio is betrothed, disguises herself as a man and as a lawyer, because you had to be a man to be a lawyer in those days, ingeniously unravels the agreement and turns the tables on Shylock. Now I'm going to read a few quotes from Portia in the courtroom scene. I'm just reading her quotes, not the responses. And it's these quotes that I will be focusing on. Upon that same merchant's flesh is thine, the court awards it, and the law doth give it. And you must cut this flesh off his breast. The law allows it, and the court avoids it. Tarry a little, there is something else. This bond doth give thee here no jot of blood. The words expressly are a pound of flesh. Take then thy pound, take thy pound of flesh. But in cutting it, if thou dost shed one drop of blood, thy lands and goods are by the laws of Venice confiscated. And then she goes on, prepare thee to cut off the flesh. Shed thou no blood, nor cut thou less nor more, but just a pound of flesh. And she goes on further. The law hath yet another hold on you. If it be proved against an alien that by direct or indirect attempts he seek the life of any citizen, the party against which he doth contrive shall seize one half of his goods, and the other half comes to the privy coffer of the state. And it is this passage of the play, the courtroom scene, which raises some interesting and I hope insightful analogies. And the four that I'd like to pick on, three which are direct quotes from the play and one which is more contextual, are the following. First, the phrase, this bond doth give thee here no jot of blood. And the question I ask is, if citizenship deprivation is the pound of flesh, which is technically allowed, what are the jots of blood which international law prohibits the spilling of? The second quote, nor cut thou less nor more, but just a pound of flesh. And here the question is, if there is a policy objective that justifies citizenship deprivation, how can this objective be proportionately met? Are the actions of the state restricted to citizenship deprivation, or do they impact on the rights of others and on other rights, which would amount to taking more than a pound of flesh? The third quote is that by direct or indirect attempts, he seek the life of a citizen. And here my question is whether the act of citizenship deprivation is a proxy measure to achieve other unlawful objectives, or are there other measures which are proxies for citizenship deprivation? And what is the real harm that the state is trying to inflict by taking these measures? And what narratives are used to obfuscate the real motive? And finally, the contextual question is that I would like to explore the wider issues and themes of racism, discrimination, and power dynamics behind the decision to strip citizenship. Now, this question actually subverts the power dynamics at play in the Merchant of Venice, where you have the discriminated against Shylock, who attempts to seek his pound of flesh, and thereby it raises a different set of socio-political and legal questions. Now, I will get to these points in due course, and I will also then conclude by asking the question, what type of a legacy does this leave us? But let me start by setting some context. First, by providing a quick overview of the practice of citizenship deprivation and how it has evolved over the last 50, 60, 70 years. And secondly, by giving a very quick overview of some of the work that my organization, the Institute on Statelessness and Inclusion, has done on this issue, particularly in regards to developing the principles on deprivation of nationality as a national security measure. So let me start with a brief history of citizenship deprivation then. Now, the power to deprive citizenship is perhaps as old as the power to grant citizenship. In fact, the choices that are made when determining and implementing the rules of citizenship are influenced as much by who, when, and upon what terms to exclude as they are by who, when, and upon what terms to include. This question of who is in and thereby who is out, as well as the rules and criteria which set the parameters of how this question is answered, have historically been understood as falling strictly within the sovereign discretion of states. It is for states to decide who their citizens are and on what basis this citizenship is granted. These are decisions of fundamental importance as they shape the polity of the state, but they also influence the way identities are formed and the way rights are enjoyed and experienced. International law, and in particular international human rights law, has evolved, however, and matured. And in that happening, a number of key principles have increasingly been recognized as limiting state discretion to set the rules and criteria for citizenship. The state still exercises its sovereignty, but now within limits. States also set the rules of the deprivation of citizenship, the stripping of a nationality once held. Here too, international law limits state discretion more stringently than in the case of nationality acquisition. The justification for taking away what is yours by right must be greater than the justification for setting rules which may exclude you in the first place, particularly if these rules relate to acquiring citizenship later in life by naturalization as opposed to by birthright. Now, over the course of our modern and contemporary history, we have witnessed some of the most egregious and shocking consequences of the power to deprive when concentrated in the hands of the few, when these powers have been unchecked by democratic institutions, and in particular when they've targeted vulnerable minorities. Deprivation of nationality was a necessary precursor both to the Holocaust and to the genocide of the Rohingya. And so, out of the ashes of World War II came the rules-based international order, which, amongst other rights, recognized everyone's right to a nationality in Article 15 of the UDHR. This same rules-based order also protected those who have no nationality and imposed obligations on states to reduce statelessness in the form of the Statelessness Conventions. However, the promise of this era has at best only been half delivered. We have stronger rules and institutions at place, that is true, but the wielders of power continue to find new ways to circumvent the trappings of the law, to justify their actions, and to shield themselves from scrutiny. And at the heart of this tug of war is the perceived tension between state sovereignty on the one hand and the right to a nationality on the other. For some reason, there is a far greater hesitancy to view the right to nationality the same way we would view the freedom of expression or the freedom of thought or any other right. In the context of most other rights, whilst wider societal imperatives can shape and restrict the right, there is no question that these are freestanding individual rights. In terms of the right to nationality, though, there is often this rather lazy assumption of a subsidiarity to state sovereignty. And I would argue that this assumption is not only lazy, it's also very dangerous. Now, after World War II, it was widely seen as no longer being democratic to deprive nationality. And this idea became anchored in international human rights law. But today, this policy is regaining traction again, and deprivation is in active use across a range of contexts. In the post 9/11 world, and particularly in the context of the threat of ISIS, a small but growing number of states have revisited and reintroduced nationality deprivation for national security measures. These measures are justified on the basis that those who join terrorist entities or engage in terrorist activities do not deserve nationality. They have turned their back on the state, they've turned their back on its values, they pose a threat to national security and to unity. In 2018, we conducted a survey with our partners on the laws, policies, and practices of 42 countries in relation to citizenship deprivation. And what we found was, over a course of 2 decades or so, an expansion of powers to deprive in a number of ways. Some of the conclusions included that a number of states, I'm just going to name a few: Australia, Azerbaijan, Germany, Kazakhstan, Kyrgyzstan, Seychelles, South Africa, Venezuela. This is just to give you a sense of the global kind of scope of the issue, have expanded their nationality deprivation powers either by introducing national security or terrorism as a grounds for revocation of nationality, or by expanding existing powers. States have also made it easier to deprive citizens of their nationality by strengthening existing powers and limiting judicial oversight. For example, the state is no longer required to actually have a criminal conviction or even judicially approve beforehand the deprivation of nationality, or there are restrictions on the right to appeal, or the executive has far wider discretion, and the threshold of proof is far lower. In the UK, for example, legislation to deprive nationality has undergone multiple changes from the turn of the century, and each new iteration has eroded the right to nationality and expanded powers of the executive. There are also questions around and patterns around whose nationality can be deprived. Many states maintain discriminatory two-tiered systems, with birthright citizens enjoying more secure citizenship than naturalized citizens. Recent legislative changes have also targeted birthright citizens, though, in Israel, the UK, and Turkey, for example. They have increased or done away with time bars to deprivation of nationality of naturalized citizens. In other words, where previously the law would have said if you've been naturalized within 5 years, you may be deprived of your citizenship. Now those time bars have been done away with. In Belgium, for example. Or the deprivation powers now even allow deprivation where it may result in statelessness, as is the case again in the UK and Italy. And then there's a question of how these powers are being used. And what we found is that nationality deprivation laws are not only used for their stated purpose of protecting national security or countering terrorism, they are also being abused and used for political repression to target journalists, human rights defenders, political opponents, religious leaders, and minorities. And this is happening again in an alarmingly growing number of countries. Now, collectively, what this survey shows is that in this new era of rising authoritarianism, the growth of the security state, genocide, and increasing populism, xenophobia, and racism, citizenship is under threat in ways not seen for generations, certainly not since World War II. And as more states instrumentalize nationality and treat it as a privilege that can be taken away, the members of minority communities, human rights defenders, dissidents, and suspected terrorists are more likely to be stripped of their nationality, facing acute human rights deprivations as a result. The growing misuse of citizenship stripping powers to target some undermines the sanctity of citizenship for all. And our concern at the Institute is both with regard to the individual right, but also with regard to the institution of citizenship as a whole. And so when ISI was first established over 6 years ago, we have been reflecting on and trying to respond to this alarming trend through our research and advocacy and other activities. In 2017, we convened a group of experts to discuss this issue. And this marked the beginning of a really fruitful 3-year-long collaboration with the Open Society Justice Initiative, the Assay Institute in the Netherlands, and Ashers LLP, a law firm which provided us with pro bono support. Through this collaboration and guided by over 60 leading experts in the fields of human rights, nationality, and statelessness, and other areas, we developed the principles on deprivation of nationality as a national security measure. And you can find these principles on our website. The principles articulate international law obligations of states and apply to all situations where states take or consider taking steps to deprive a person of nationality as a national security measure. But the principles also, I would argue, apply to wider context of nationality deprivation, even where security isn't the stated objective. The principles restate and reflect international law and legal standards under the UN Charter, treaty law, customary international law, etc. And it's really important to emphasize this. The principles don't create something new. They are not a creative exercise of developing new standards. They merely collate and synthesize existing standards. But the power of the principles is that it brings together this body of work and it presents it as one. And by placing all of these standards together, it shows exactly how strong the protections against citizenship deprivation are. In addition to publishing the principles, we also published a World Status Report, to which Professor Bertram also contributed a really insightful perspective. And the principles have been widely endorsed by individual experts as well as organizations. And we have now based the principles, used the principles as a basis for a year of action against citizenship stripping, through which we are working to kind of draw more attention to these issues. For anyone who's interested, there will actually be a global seminar series on the topic hosted by Kaya Blix, one of my colleagues. And this will kick off in mid-February with what I do not doubt would be a fascinating talk by Professor Matthew Gibney of the Refugee Studies Center. And you will find more details in the chat here as well as on the ISI website. But that aside, let us now get back to The Merchant of Venice. And my 4 points are comparison and analogy. So the first point, and let me remember, let me remind you, this is the quote: "This bond doth give thee here not a jot of blood." Now, as I mentioned earlier, there is no explicit or blanket prohibition of nationality deprivation under international law. In fact, there is wide recognition that it can be a legitimate response in the context of fraud, for example. But barring such very limited circumstances, it is extremely difficult, if not impossible, to deprive nationality while complying with international law. And so the principles articulate a basic rule that states shall not deprive persons of nationality for the purpose of safeguarding national security. This exercise, uh, and it further goes on to say that any exception to this rule must be interpreted and applied narrowly, and is further limited by other well-established standards of international law. And these standards are the avoidance of statelessness, the prohibition of discrimination, the prohibition of arbitrary deprivation of nationality, and the right to a fair trial, remedy, and reparation. And these are the jots of blood that shall not be spilled. So let's look at them a little more closely. The duty to avoid statelessness has been described as a fundamental principle of international law and is widely acknowledged as an obligation of customary international law. The UN Secretary General, for example, has said that the avoidance of statelessness exists as a corollary to the right to nationality itself. And states must make every effort to avoid statelessness through legislative, administrative, and other measures. This principle has been reaffirmed by various regional human rights courts. For example, the Inter-American Court in the Ana Embosico case held that the obligation to prevent, avoid, and reduce statelessness must kind of underpin state actions related to nationality. And similarly, the African Court in the recent Anudo case uh, articulated that the power to deprive a person of his or her nationality has to be exercised in accordance with international standards to avoid the risk of statelessness. Now, importantly, the burden should be on the depriving state to ensure that statelessness isn't a consequences. And this doesn't mean that there's a hypothetical potential nationality that the person may have, but rather that at the time of deprivation, they have another nationality. Many countries actually do abide by this principle and recognize it, and they treat it as a red line that cannot be crossed. But there are a number of countries which still decide to cross this line. The second jot of blood is that of the prohibition of discrimination. Now, we all know that the prohibition of discrimination is one of the foundational tenets of international human rights law, and I don't need to elaborate in any greater detail about how this shapes our understanding of rights and their enjoyment. But I think one important and perhaps less known fact is that the 1961 Convention on the Reduction of Statelessness contains a blanket prohibition of deprivation of nationality on racial, ethnic, religious, or political grounds. Now, this is important because the 61 Convention, it actually does allow for citizenship stripping in certain circumstances, and circumstances which we would argue other international law standards have since plugged. But this blanket prohibition of deprivation remains a really key contribution of the 61 Convention. Now, we also know that the prohibition of racial discrimination is a peremptory norm of international law. But it is important to contextualize this prohibition within the historical use of deprivation of nationality by states. And here I'm going to quote the words of UN Special Rapporteur on Racism, Tendai Achiume. And she says, historically, citizenship stripping has been a favored political tool for ethno-nationalist governments wishing to isolate, marginalize, or exclude certain racial, ethnic, religious, and national groups. Thirdly, I would like to point to the third jot of blood, the prohibition of arbitrary deprivation of nationality. Now, Article 15.2 of the UDHR very clearly stipulates that nationality deprivation shall not be arbitrary. And there are a number of components to what arbitrariness is, including a legitimate purpose, a firm legal basis, necessity, proportionality, and procedural safeguards. And all of these apply, but I think I would just pick on the necessity argument as something which really can put states into a spot of bother, states that play the avoidance of statelessness rule against the non-discrimination rule. Now, the problem with this argument is that the state is acknowledging that there are different, less intrusive, but equally effective ways of dealing with the security threat posed by citizens who do not possess dual citizenship. If a state is saying if it only strips citizenship of those who have another citizenship, that's precisely what they're saying. And then the question arises, why can't such measures be applied to dual citizens as well? And does that mean that it is actually not necessary to deprive citizenship or dual citizens? I'm just conscious of the time, so I'm going to move on to the second quote that I would like to reflect on. And that is the quote, "Nor cut thou less nor more, but just a pound of flesh." Now, when cutting the pound of flesh, with cutting the pound of flesh, our only concern isn't whether any blood is spilled. We are also concerned about whether the state cuts off more than a pound of flesh or not, and whether a pound of flesh is actually the right amount to be cutting to begin with. Why not half a pound or a quarter pound? And would this be a travel ban or a confiscation of passports, for example? This set of questions can be translated as the proportionality principle, which is incorporated in the concept of arbitrariness, but also deserves to be looked at separately. The consequences of a decision to deprive someone of their nationality must be assessed against the proportionality principle. As such, the direct and indirect human rights impacts on the person and their family members, in particular their children, must be taken into account. And so an individual assessment must be carried out. And what are the other rights that are typically at stake? The principles on deprivation of nationality look at the right to remain and into one's own country, the prohibition of refoulement, the freedom from torture, the liberty and security of the person, legal personhood, the right to family and private life, and the rights of a child. And these are all factors which must be assessed. And I would wager that they aren't effectively assessed whenever a state does take a decision to deprive. The third is the phrase, the third point that the analogy that I would like to make is related to the phrase that by direct or indirect attempts to seek the life of a citizen. Now, there's clearly a lot more to Shakespeare's A Pound of Flesh than the legal and linguistic arguments around it. The underlying question is the motive of good faith. Everyone knew that Shylock was after something more than a pound of flesh. And this was actually, he wanted to get back at Antonio. And he tried to use the letter of law to do so, the perfect crime, perhaps. And so we must scrutinize the often complex and muddled relationships between the narratives that states use related to citizenship deprivation and the real objectives of those who wield the power to deprive. Because often there is a hidden motive and there's something else that they're trying to achieve. As I have elaborated previously, international law imposes quite significant limits on the utilization of citizenship deprivation. Consequently, states have to justify both internally and externally why they choose to introduce or expand or utilize these powers. And often the real objectives cannot be stated, as these would not withstand the scrutiny of courts or other forms of oversight. And so proxy reasons and narratives are often woven into the discourse. And through these, deprivation is justified and rationalized. And they tend to embrace themes like national security, patriotism and loyalty, belonging and identity. They invoke the idea that the state serves the nation, and anyone who is not part of the nation or is disloyal to it has no place in it. These narratives thrive on populism and othering minorities. And so it's important to really scrutinize the underlying objectives and see why states are trying to actually use these powers and who ultimately pays the price. I will end by this wider contextual reflection that I wanted to make on the question of racism and discrimination and power dynamics. Now, a very different but equally interesting thing to unpack is the wider power dynamic at play. Shylock is a Jew living in an overtly anti-Semitic society. He is a minority, the discriminated against, and the minority. Now, one cannot but think that if the boot was on the other foot, and if it was Antonio in Shylock's position, that the courts and the system would perhaps have pushed for some kind of a settlement. Because Shylock was, it's because Shylock was a minority and a marginalized person that this level of extensive punishment was finally kind of imposed on him. Now, in the context of modern day citizenship stripping, all the power is wielded by the state that is seeking its pound of flesh. And the individual at the receiving end is more likely to be of a minority whose belonging is anyway questioned. And so it is in this context that states are able to, despite very strong international law standards against citizenship deprivation, as I've articulated, able to still proceed and continue to, with impunity, I would argue, deprive citizenship of individuals, often targeting minorities. And it is this that is at stake, and this is what we are trying to fight against and address through our work, and which is what we're trying to also articulate to the principles. So let me stop there because I think I probably rambled on for long enough and hand the floor back to Kate. Thank you.
Thanks very much, Amal. A lot of information there and really interesting. And I'm now going to turn to Christopher to respond.
Thank you, Kate. So I'd like to thank Amal for a really interesting and challenging presentation, much of which I somewhat inevitably agree with. I really liked his elegant use of the pound of flesh argument from Shakespeare to talk about these issues. And the principles on the deprivation of nationality as a security measure that he talks about represent a fine set of principles which, if adhered to, would reduce the risk of individuals and groups being subjected to serious injustice. Amal is right to say that the use of national security is a pretext, often a very flimsy one, for carrying out measures of denationalization and denaturalization that place individuals at risk of statelessness, both de jure and de facto, which undermine the unity of the citizen body by creating citizenships of different values and qualities, and which stigmatize and discriminate against individuals and groups who are not part of the majority population and who are not perceived as part of the national group in the nativist imaginary. I'm going to concentrate on two things in my response. Firstly, the gap that we all know about between high principles and what states actually do. And then second, I want to say something about the motives for citizenship deprivation on the part of states, and to highlight an angle that I think gets a bit neglected in these conversations, namely the overlaps between the citizen deprivation issue and the deportation and foreign criminals issues. And essentially, in both cases, we're talking about states, usually wealthy ones, dumping unwanted people onto usually poorer states. So first of all, then, at the same time as agreeing with what much of the spirit and substance of what Amal has said, I find myself worrying about what, if anything, can make these grand principles effective in the real world. The UK government, for example, is in principle signed up to a commitment that citizenship deprivation should not leave a person stateless, though it operationalizes these commitments slightly differently for people who've acquired UK citizenship in different ways. The key safeguard is merely that the Secretary of State has to satisfy herself that the person concerned is either the national of another state or, in some cases, is entitled to become one. Now, in one of the crucial cases, that of Pham, the person deprived of British nationality had come to the UK at, I think, the age of 6, though he was born in Vietnam. And the UK wanted to deprive him of his nationality on grounds of his involvement with Islamist groups. as I recall. But when an attempt was made to judicially review the attempt to deprive him of his nationality, his British nationality, the attempt failed because, as I understand it, it could not be shown that on the date of the deprivation decision, Pham was not considered as a national of Vietnam under the operation of Vietnamese law. Now, I'm not a lawyer and I don't pretend to be on top of all the legal technicalities, but what's striking to me here is that despite the UK's commitments to international human rights conventions, the pressure on the Home Secretary to ensure conformity with these commitments was exceedingly weak, and the burden of proof was on the challengers to show that the decision was an unreasonable one, a very hard test to meet. In other words, there was no positive and enforceable duty on the Home Secretary to see to it that Pham was not rendered stateless. And there's something of a parallel here, I think, with other areas of human rights law, take refugee and asylum law, where the UK, on the one hand, is, along with other states, signed up to the Refugee Convention, for example, and where the Home Office endlessly repeats they have a proud record of giving sanctuary to the persecuted, a claim that doesn't survive much in the way of historical scrutiny. But here, what the lay observer might regard as the plain meaning of the commitment entered into ends up as something entirely different, as the state actually makes sure that as few people as possible are actually in a position to claim asylum. And recent announcements by the Home Office look to make this even worse by declaring that many of the people who do get onto the territory, who don't get onto the territory of the UK and who meet the convention definition of refugee have claims that are deemed as inadmissible because they pass through a country deemed to be safe on the way. As my friend Sarah Fine has observed, there can be a great deal of difference between being in a safe country and being safe in that country. So in other words, looping back to the statelessness issue, the point I want to make is that it's all very well for us to try to develop international human rights law and to incorporate all kinds of safeguards within it, but such law doesn't enforce itself. And it can be very easy, and far too easy, for states to accept a set of principles, sign up to the conventions, and thereby bask in the legitimating glow of international human rights law, whilst in practice failing to defend human rights and even working actively to undermine them. So perhaps we need a shift in the conversation to ensure not only that we have the right principles, but also that we have the mechanisms to ensure state compliance. And that's obviously easier said than done, I know. On the second point then, I wanted to talk about, which is this continuity between the practice of citizenship deprivation and what's been going on with foreign criminals and deportations. For while I agree with the claim that national security justifications are bogus, and with the observations that are widely made that citizenship deprivation undermines citizenship as a unitary category and unjustly stigmatizes minority populations, either intent or in effect, I think we shouldn't neglect another, in some ways more prosaic motive behind state actions. That's to say, there's an opportunistic policy of the state using the legal tools at its disposal simply to wash its hands of some people and to refuse responsibility for them. In the case of people who straightforwardly hold another nationality and not the nationality of the country that designates them as a criminal, this can often be straightforward enough from a legal, if not from a moral perspective. Though we might worry about the morality of flushing away people who've grown up in a country and are social members of society, as well as the morality of inflicting a double punishment on them, the prospect of removing these, quote, undeserving citizens from the state to a place where they're someone else's problem and someone else's cost is, from the government's perspective, quite an attractive one. But what then of the people who are perhaps not thought of by a large proportion of the native population as, for example, being fully or properly British, but who hold a British passport? We can make the same, distinctions for other passports. They are, to use the categorization of the French proto-fascist intellectual Charles Maurras, members of the pays légal, but not of the pays réel. A simple solution from the exclusionary and nativist point of view is to redesignate them as foreign, to remove their, quote, artificial British citizenship and thereby make them available to be either deported or if they're inside the country, or to exclude them permanently if they're not. And we've seen this process at work in the UK since 2016, with the first cases involving men of South Asian origin involved in sexual exploitation cases. Obviously, such individuals weren't going to be the recipients of public sympathy, but having established the precedent that citizenship deprivation can be used in cases of serious criminality, it's only a short step from there to the expansion of its use against people convicted of a much wider range of offences. In the case of straightforward, quote, foreign criminals, i.e. those without British nationality, we've seen those claims about serious criminality used to justify the deportation of people who've committed, say, drug offences, and even in some cases, I think, driving offences. So it's not a great leap to imagine increased use of deprivation powers against wider groups of unwanted persons of non-majority ethnic background. They can be dumped as someone else's problem, just as long as that someone else is willing to take them or can be bribed or threatened to do so. So then to sum up, I agree with Amal that the national security justification for citizenship deprivation is largely bogus, and that both the intent to some extent and the effect of citizenship deprivation is discriminatory and pernicious. But I think this fits into a wider project of states getting rid of people they don't want. In the end, defeating that project will not be achieved merely by the promulgation and refinement of international declarations and conventions and international human rights law, very necessary as all that is. We also need to find ways of getting states to comply with these standards, the standards they purport to uphold, and doing that is going to be a political problem. So I'll stop there, and we can take up some of these issues in the Q&A. Thanks.
Thanks very much, Chris, and thanks to Amal, to both of you for really interesting engagement and a very interesting response. I've just to remind everybody that you're very welcome to put questions, so please do put any questions you have to our speakers in the Q&A. But I thought I would kick off by sort of asking the question to Amal as to what extent does, for example, the right to nationality in the Convention on the Rights of the Child play into this and make this at all different?
Thanks, Karen. That's a great question. So under the CRC, Article 7 protects every child's right to a nationality, and it goes on to articulate that a state has a particular obligation to ensure that no child is born stateless. And then Article 8 says that if a child has been unlawfully denied or deprived of their identity, and the CRC includes nationality as a component of identity, that the state needs to take remedial action in order to reinstate that identity, in this context, that nationality. So the CRC, when you also look at Article 7 and 8 in combination with the general Article 2 prohibition of discrimination and the Article 3 kind of focus on the best interests of the child, you have a very strong bucket of rights which together provide very strong protections. The problem is when you look at implementation, this hasn't really translated into states taking action to grant children nationality where they would otherwise be stateless. And we have also seen in some countries this idea of derivative loss of nationality, whereby if a parent is stripped of their nationality, that then the children are also vulnerable to being stripped of their nationality. And so, I mean, this goes to Chris's point as well, where we have this discrepancy between strong international standards and poor implementation. And of course, this is the perennial problem that any international lawyer faces. But I would think that the CRC, in terms of the international treaties, is one of the stronger ones on the right to nationality. And there's been some very encouraging recommendations and concluding observations by the committee. The committee has really, in the last 10, 12 years or so, got behind Article 7 and started making clearer, more complex and nuanced concluding observations and recommendations in relation to the child's right to nationality. And so I think there's a great body of work that can be built on, but the work remains to be done to actually see this universally applied and translated into the policy space.
Yeah. Thank you. And I mean, I wondered if you wanted to respond to kind of Chris's 2 points. You raised now the question of implementation as really being one of the kind of greatest challenges. I mean, would you like to respond to what Chris had to say?
Yeah, I mean, absolutely. And I agree with both of your points, and I'm glad that you made them. The farm case in particular, it was actually a very problematic a set of judgments as the case went through the courts, because there was this presumption that the British courts had jurisdiction to interpret Vietnamese law, when the Vietnamese authorities had very clearly stated that they did not consider Pham to be a citizen. And you may argue whether the Vietnamese authorities are right or wrong in having decided so, or having articulated their position as such. But that is actually irrelevant, because as far as the UK is concerned, the question is whether Pham would be made stateless or not. And this is not a question of right or wrong, it's a question of fact. So it doesn't matter whether Vietnam is correct or wrong in how it interprets and applies its own law. What matters is that Vietnam is the competent authorities of Vietnam are the only entity that are able to do so. And it's not for another state to do it on their behalf. And there's very clear guidance on this point in UNHCR's guidelines on statelessness. And it's a shame that most states haven't looked at these guidelines and used them as a basis for decisions related to nationality deprivation, but also related to the acquisition of citizenship. In terms of your other point about the wider kind of ecosystem, so to speak, and states, the slippery slope argument, as well as states using other powers. I mean, I would fully endorse and agree with all of this. And what I would like to say is that there are a number of reasons why it's really important for us to look at this question and be deeply concerned with what's happening in terms of nationality deprivation. And I didn't get to this when I was speaking, but if I may take a minute or two now, I would just like to pick out 4 of those reasons. One is the fact that this is a permanent measure. It's not like a prison sentence which someone serves and then they're able to reintegrate into society. Nationality deprivation has a permanence to it, which impacts the individual and their families. And so it needs to be treated as having that type of a permanent impact on people and communities. Secondly, the fact that nationality is an enabling right. And without nationality, you're denied access to so many other rights. And this is the proportionality argument I was making, and the kind of the other rights that are impacted as well. And this means that, again, you need to have a really strong reason to deprive nationality, because by doing so, you're pulling the carpet from under someone's feet, and you're exposing them to violations in relation to a whole host of other rights. I think then there are wider kind of existential questions about the type of communities and societies we want to live in, which are democratic and rule-abiding and based on certain values. And what messages the act of citizenship stripping actually present in this context. And Chris, your point about powerful states exporting a problem to less powerful states. And finally, if I may, I know I'm going on a bit here, but there's a really important question about state sovereignty. And the reason I raise this is because this is the argument that's presented by states. We have the sovereignty to decide who is a citizen and who is not. But I think it's really important to interrogate this, because in most states, actual sovereign power rests with the citizens. And it is the citizens who elect their representatives, who then form the legislature and the executive, etc. And if the executive, because most often it is the executive, can then shape and remodel who its citizens are, it's basically a context of the representatives disenfranchising the represented. And that's deeply problematic for societies and for democracies. And it's what's happening in the context of Myanmar with the Rohingya, or India with Assam, where you have minorities being pushed out of democracy through states taking these powers. So these are all reasons as to why we should take this issue really seriously and not treat it as just a niche issue that's impacting on 5 or 10 people in the counterterrorism space.
Thanks, Amal. Chris, do you want to respond to that at all?
Well, I just wanted to just on the last point that Amal raised. I mean, this question of you raised the spectre of the state using citizenship deprivation powers to decide who gets to be a citizen in a context where citizens are supposed to be sovereign. And I guess we could relate that to a kind of somewhat broader pattern, which is the phenomenon where you've got a lot of people on the territory of democratic states who you might think have a moral right to citizenship. They're fully members of that society, but are not being admitted to democratic rights, democratic citizenship. So you've got that mismatch coming in from that direction as well. So I'm thinking about people like the so-called dreamers in the US. Perhaps we could think about EU citizens in the UK as also falling into that category. So they're people who kind of live and work on the territory. They may be functionally part of that society, but they are also outside of the sovereign citizen body. But the other thing to say about kind of democracy and sovereignty and the sovereign people, though, which I guess pushes in a slightly different direction, is that part of the worry is that actually the pressure to in a context of kind of populist politics, the pressure on politicians to disregard some people as not being kind of really part of the demos, not being really part of the citizen body, is coming from nativist citizens themselves and from populist discourses articulated in the wider population. So that would be a concern.
Thank you. Well, we've got a couple of questions from the audience. I'd like to put those now. So the first one relates to the UK Immigration Act, and in particular section 66 of this. And it's been pointed out that that provision says that the Home Secretary must merely have reasonable grounds for believing that a person is able to become a national of another country before stripping that person of citizenship. And the question is really whether that's not much lesser standard than the kind of actual established entitlement to citizenship of another country. And does this call into question the UK's actual commitment to its principled statement against statelessness?
Yeah, I'm not a British lawyer, but I mean, on reading of it, yes, and by example of some of the decisions of the courts as well, I would say definitely yes. Yeah.
Yeah, I would agree. Yeah.
Yeah. I suppose while we're on that, I just wonder, are there any examples of domestic legislative practice which are more rigorous in this regard? In other words, either a kind of, so where in relation to a citizenship stripping provision, actually require it to be established that the person is in fact a dual national or is, as Lucia says, entitled to citizenship of another state. Are there countries that do formulate it in that way?
I would have to look that up to answer that question accurately. I mean, my guess is that there are, because there tends to be a whole spectrum in terms of how states approach the issue, and also how willing states are to deprive citizenship. So my guess is that there will be countries that have much stronger criteria. The one thing I would say, though, is that it's a very dangerous combination when bring citizenship stripping in collision with the issue of security. And what you find is that regardless of the system or the standards at play, that courts are more likely to be differential to the executive the moment issues of national security and counterterrorism are kind of the issues that are being decided upon. So regardless of the level of the standard, where I'm sure there's a whole range, my other educated guess would be that courts would be more differential to the executive, where it's a national security measure.
I mean, just on that, it's interesting that the South African Constitution actually has an express prohibition on the deprivation of citizenship from citizens. Like all of the rights in the South African Bill of Rights, that's obviously subject to the General Limitations Clause, which says that if the state can show that it would be reasonable and justifiable in an open and democratic society to do that. But it's such a clearly, I don't think there's been any jurisprudence on it, but such a clearly formulated prohibition that one does wonder what the kind of considerations might be that would allow the state to deprive people of citizenship. And it may well be that there are a range of jurisdictions that have similar prohibitions on citizen stripping in bills of rights.
In the context of the UK, I mean, you've got this very loose language about reasonable grounds, but also you've got a system of judicial review that is really really puts the onus on the challengers to show that the decision was kind of manifestly unreasonable. It's not as if the courts or anyone else is really going to go into the underlying grounds behind the decision, and to look at whether they're justified. So you've got a whole kind of mountain to climb if you're going to challenge a Home Secretary's decision on that kind of thing.
Yeah, it's where it's the intersection, in a sense, between administrative law and rights. And in some Bill of Rights systems where citizenship is formulated as a right, then you're not actually in the administrative law model of judicial review. We seem momentarily to have lost Amal. I hope that he will get back to us, but I'm going to put the other question as well, Chris, and see if you've got comments on it. I'm going to go to the one that's actually directed not just at Amal, and hopefully we'll get him back before too long. Okay. So the next question is whether how one squares the idea that nationality is an enabling right with the fact of dual nationality. Much of the literature makes the point that the enabling quality of the right only entitles one to possessing citizenship somewhere, but not to possessing any particular citizenship. So I think the point probably is that, once you have one citizenship, what sort of rights do you have under your dual national citizenship, given that actually you now have citizenship in one place?
Well, so what I'd say about that is that the dual nationality, although it's kind of frowned upon by some jurisdictions, actually kind of reflects as a practical matter, the world in which we live, where people often have kind of memberships and connections and lives that span different jurisdictions. I mean, in the kind of distant past, where people were very worried about kind of dual loyalty, and there were kind of issues about kind of conscription and national service and war and so on. I mean, I think those kind of concerns are where kind of prohibitions on dual nationality come from originally. But as a practical matter, people, given those kind of border spanning and society spanning lives, often need the protections of more than one nationality in order to be secure in their basic rights.
That's right. I mean, a lot of the benefits and rights of citizenship actually adhere in a particular polity. So whether it's the right to vote or reside or whatever, if that's where you are, the fact that you might have the right to vote somewhere else, I suppose, is not an enormous benefit. Amal, this was a question that went to the fact that quite a lot of the literature see the right to citizenship as an enabling right, which suggests that you're entitled to citizenship in some place, but not necessarily more than one. And if you have citizenship somewhere, then perhaps the underpinning normative framework of enabling an enabling right isn't as strong as it would be in circumstances where you in fact don't have another nationality.
Yeah, I think that's a really good question, and I'm sorry my internet dropped for a moment there. The challenges of homeschooling and kids being also on Zoom classes, but yeah, I mean, I think this question also relates back to the idea of who the duty bearer is, right? So with most rights, it's quite easy to identify who the duty bearer is. But if you do have a right to a nationality, where does the duty lie to ensure that you're able to enjoy that right? And what we find in the nationality rights and statelessness field is that we tend to focus on countries with which an individual has a strong connection. So by birth or descent or through marriage or through residence, for example. And it would be those few countries which then between them have a duty to ensure that the person is not stateless and thereby that the person's right to nationality is protected. And I think the same reasoning can be applied to this question of enabling rights. So where do you, in what context does nationality actually serve as an enabling right? It's in the context of you living within a society and within a community, and you being able to live in that community and in that society as an equal, and you being able to enjoy the rights which you should be able to enjoy without discrimination. Now, in an ideal world, nationality would not be a bar, or the lack of nationality would not be a bar to you enjoying certain rights. But the reality is that there are restrictions which states impose, many legitimately, but also many illegitimately, on non-nationals in terms of their access and enjoyment to rights. And in reality, if you are a citizen, there are less barriers to accessing rights, but also it's easier, at least technically, to assert your rights and to access justice if you've been denied them. So I am actually a little bit uncomfortable with the whole framing of nationality as an enabling right. I see why practically it is the reality that we live in. But I would say in pure human rights terms, there are very few rights which are actually restricted to nationals. The right to vote, to some extent the freedom of movement, but even that is not as clear as it would first appear on face value. But most other rights, it really shouldn't matter whether you're a citizen or not.
Well, thanks very much on that. And I'd like to turn to another question, which is that the questioner understands that the principles upon which you've been talking about today, developed by the Institute, are based on the idea that any prohibition of or any prohibition on arbitrary deprivation of citizenship triggers a kind of proportionality test, where the arbitrariness will be measured against the sort of principles of a proportionality exercise. And he wonders, or she wonders, what substantiates such reading of the interplay between the two, given that normally we would only apply the proportionality test to evaluate the restriction on limitable rights, association, privacy, but not against a rule such as the prohibition of arbitrary deprivation. And goes on to say, if the reading is mistaken, it is not the prohibition of arbitrary deprivation, but the right to nationality that triggers the proportionality test. I wonder how the right has been conceptualized and what it means to have the right, besides the right of a child to have their parents' citizenship and not be rendered stateless. There's really a question of how arbitrary and the proportionality test fit here, whether we're talking about a right not to be arbitrarily deprived of your citizenship, or in fact a right to citizenship, which may only be limited circumstances which would be proportionate.
Yeah, I mean, I would say it's the latter, but I would encourage the person who asked that question, which is quite a technical one, to take a closer look at the text of the principles themselves. So basically what the principles do is they assert that everyone has the right to a nationality. And there's a very extensive commentary to the principles which provides all of the legal basis for each kind of provision in the principles. So the principles assert that everyone has a right to a nationality. And then it acknowledges, they acknowledge that in certain circumstances, states may be entitled to deprive people of their citizenship. But then it sets out the various international standards which must be taken into consideration and the various thresholds and criteria that must be met in taking those decisions. And these relate to the avoidance of statelessness, the prohibition of discrimination, the prohibition of arbitrariness, the right to a fair trial itself. And proportionality is a concept that comes within the notion of arbitrariness. So an expansion of the arbitrariness tests would include there being a legitimate purpose, it being necessary, it being proportionate, there being a clear legal basis, etc. But then what we also find is that in addition to going through this process, we also need to think about the implications on enjoyment of other rights. So does deprivation of citizenship lead to a situation where the person may be subject to refoulement? Or does it lead to a situation where the person may be subject to indefinite detention, which amounts to cruel, inhuman, arbitrary, or inhuman treatment or punishment? Does it amount to a situation in which the right to private and family life is impacted on, etc.? And in these contexts as well, the proportionality question comes into play again. So I don't think it's about do we look at whether the arbitrary deprivation of nationality is proportionate, but rather we look at how the principle of proportionality comes into play at various points when determining whether there is a legitimate basis upon which to deprive nationality.
Chris, shall I move on to the next question, or anything you'd like to say in relation to that?
No, that's fine. I'll pass on that one.
Okay,
thanks.
Good. So then the next question is the extent to whether you know whether there's a right for states to deprive people who are deceased, who have died, of their right to citizenship, which of course may have implications for their descendants, and it may, for example, be in the context of counter-terrorist measures or anything of that sort. Is that something about which you, whether you know that that's been called upon or relied upon by any state?
The posthumous deprivation of nationality. It's a really interesting question. I don't know, but it's something worth looking into.
Chris, any comments on that?
No, I'm trying to think if I'm aware of any cases at all. I mean, there may be cases where it's deemed that someone had never been a citizen of a particular state, I suppose, or never really been a national of a particular state. But I'm struggling to think of examples to make that more concrete. Yeah,
interesting, because you would imagine that it would have to be sort of retroactive in that way in order to affect children who might have, vested a right while the citizenship existed. It would have to mean that the citizenship never existed. Anyway, it's an interesting question. Thanks for that, and we'll continue to think about it. So there is one of the people who've attended has made a comment to say that they're not a lawyer, but and that really liked the use of the Merchant of Venice analogy because it helped understand the legal principles and the issues that lie behind these processes. And the listener says that it made him or her think of three things. One is the veneer of decency and procedure that shields the racism of Portia in the Merchant of Venice. Secondly, the public spectacle that Shylock is subject to as he's scrutinized, and how would he recover from this, the sort of dignity aspects of it in relation to Shylock. And finally, the fact that what seemed to irk Antonio and the crowd was that Shylock was asserting his rights claimed by the society they belonged to, and they are outraged that he sort of dared to demand his rights. So it may be more of a comment, but if either of you would like to comment on that, it does seem to me that it has parallels in our modern experience of citizenship and discrimination.
I mean, go ahead. Yeah.
No, you go ahead first, Chris.
Well, I was just going to say something that I think is so you've got kind of two things going on. You've got the kind of prevailing kind of norms and moral expectations, and you've got the letter of the law strictly applied. And I think one of the things that's been more and more marked in this area, but also in kind of refugee law, is a draining away of a substantial commitment on the part of politicians, the political class, and so on, to the kind of values and culture of human rights, at the same time as a kind of rather kind of dogmatic insistence upon the letter of the law, so that, you know, just so long as you can show that a decision is in conformity with some legal standard, that makes it okay. And I think what we need to foster is a kind of greater public commitment to the kind of norms and principles and values of human rights on the part of the political class and the legal class to stop that kind of thing from happening.
Yeah, and I would add to that. I mean, I think particularly in industrial countries, and I would look at the UK, for example, you find this putting up of a huge array of really complicated procedures and processes, which on the face of it, it seems like if a person manages to navigate this and get from point A to B, they will be treated fairly. But in reality, these processes and procedures are designed to intimidate and to confuse and to make it really difficult for people to get through the system. I mean, I've spoken to immigration detainees in the UK who speak of feeling like a spider, speak of being stuck in a spider's web in the context of the procedure. So there's a certain violence of bureaucracy, which has this veneer of being neutral, which actually is deeply racist and deeply problematic. So I fully agree with that observation in terms of the question. And I also think, I mean, it's interesting, right? You look at Shylock's character, and here's a guy who, on the one hand, is deeply discriminated against and abused and subject to anti-Semitism and racism. And on the other hand, he has a nasty streak to himself, and he kind of, drawing on whatever nastiness he has within himself, he decides to make an example out of Antonio and assert his rights. And so you have this situation of the minority having the audacity to claim their rights, but also having the audacity to not be good. And we find this all the time in the contemporary world, where if you are a refugee, if you are a migrant, you have to behave a particular way, you have to be a good refugee. And if you are not, you will be subject to the wrath of society, which feels that it's not your place to act in a certain way or to claim certain rights. So absolutely, I mean, I think the play just there are so many deeper levels at which it can be understood and kind of applied to the way the law and society kind of operates today. Absolutely.
I mean, a lot of what you're saying resonates with what we learned from Windrush. And not long ago, we had Wendy Williams talking about her lessons learned review in relation to, you know, how to create a hostile environment in relation to people who actually did have a right to reside and remain in the United Kingdom and whose families had been invited here in the first place. But just now turning to the last question, which raises sort of somewhat similar issues, and that is the way in which the prohibition on citizenship stripping might fit with a requirement that one state imposes on a citizen before that citizen applies to get citizenship with another state, or even where they're entitled to it. The idea, in a sense, that a state wants to prevent you exercising your right in relation to another state if you do enjoy that right. Do you see this in the same way, or does this come back to the questioner who talked about, well, you're entitled to citizenship in one state and not necessarily in any more?
Well, it's interesting, right? So it's I would say completely within the prerogative of states to decide if they would allow or not allow dual citizenship, or if they would impose some criteria in relation to dual citizenship. And I mean, personally, I think that that's problematic in terms of my own personal philosophy, but in terms of the law, that's absolutely fine. And so then it's more of a question of how the rules of different states play against each other, and whether they leave room for people to fall within the gaps, or more often to be pushed between the gaps. And this is what happens, for example, in the context where you may have an overseas British citizenship, which, as Chris mentioned before, is a citizenship only in name, but it really has no value to it as such. And so can that be used as a basis to deprive you of another citizenship? And where does that leave you? So I think there are challenges with how we deal with and implement varying rules and approaches to dual citizenship. But these are challenges which can be overcome if states are law-abiding and rule-abiding and respect their international obligations. The problems arise when states refuse to do so.
Yeah, I mean, worth noting in the context of the UK that the measures that the UK has to kind of mitigate the kind of risks, say, of children not acquiring a nationality, the registration procedure, for example, that's been made kind of systematically more difficult for people to access over the last 10 years. So the fees in order to register to be kind of British for a child have gone up and up and up, to the point where a family with several children in that position is going to face perhaps an unsurmountable financial burden just to assert that legal right. So I mean, that's what happens where there isn't really a substantive commitment on the part of the state to addressing that problem, and indeed perhaps a will to keep people out.
Well, I think that brings us to the end of all the questions we've had, and I'd like to just thank both of you for really interesting comments and presentations, and also for the responses to the questions. I think this is a very important issue, and for the discussion on the 8th of February on the questions of immigration and empire, and Wendy Williams, who I just mentioned, who was the author of the independent investigation into the Windrush scandal and wrote the report Lessons Learned, will be one of the speakers at that, as will Professor Alex Welsh of the University of Liverpool, and Farida Banda, Professor of Law at SOAS. So if you'd like to register for that, look on our website and you'll be able to see where to do that. And then to remind those of you, the regular attenders at our discussion group next week, will be investigating the challenges to legislation that imposes discrimination against LGBT people, arising particularly in the Commonwealth, criminal prohibitions attaching to male sex in particular. And that will be led by Taya Brown of the Human Dignity Trust, which has been very involved in bringing litigation in a range of countries around the world to challenge such legislation, and responded to by my former colleague Edwin Cameron of the South African Constitutional Court. And I think it'll be a very interesting conversation. So that'll be next Tuesday at the same time. So it just leaves me again to say thanks again to Amal and Chris for a really interesting conversation, and to thank all of you who've been here and for all your interesting questions, and to wish everybody can keep well and keep safe. And hopefully we will get through to the end of this pandemic before too long.
Thank
Take
you.
care.
Thanks. Bye.